Good morning, everyone, and welcome to the last of our webinars for 2021. Thank you very much for joining us this morning. For those of you that don't know me, my name's Emily Wood and I head up the real estate disputes team here at DMH Stallard. For our webinar today, we thought we would depart slightly from our usual format. As we come to the end of this year, we wanted instead to have a discussion between some of our most frequent speakers across our real estate teams and ask them to give you their thoughts about what we may or will see in the world of real estate and planning for the year ahead and beyond. So joining me this morning, we have James from our real estate disputes team, Jonathan from our commercial transactional team, and Chloe from our planning team. The subjects we're going to cover this morning and the discussion we're going to have come under three main themes. We're going to look at the future of commercial occupiers, then move on to what is ahead in the residential arena, look at real estate and the green agenda, and then at the end have a wrap up of anything else that we see on the horizon. As usual, we should be done and dusted in about an hour. We won't be having detailed slides this morning because of the nature of the discussion, but we will be publishing an article after the webinar covering some of the topics we cover as well as some others that we see on the horizon. As always, really welcome your questions and even your own predictions for the future on the topics that we discuss. Please use the Q&A function on your screens to do that, to raise any question or comment. If we have time to address them at the end, we will of course do so, but we'll certainly email you with our responses if not. If you have any technical issues at all during the webinar, then please use the chat function on your screens and our marketing team behind the scenes will be able to assist you. So let us begin. The future of commercial occupiers. Now, everyone here will only be too aware of the enormous levels of debt which have arisen during the pandemic as retailers, hospitality venues, leisure facilities, travel companies, to name some of the more obvious types of tenants, were unable or some even unwilling to pay their rents to their landlords because they couldn't use their commercial properties. Now, James, I know you've been looking at the new bill which has been introduced by government in an attempt to sort of curb the otherwise influx of court proceedings against commercial occupiers for these debts. Do you think it will result in a brighter future for commercial tenants?
Thanks, Emily, and good morning, everybody. Yes, I think it may well do for some, but it will depend on the type of business which has accrued the arrears. Not all of the tenants will be able to take advantage of the proposed new arbitration process, which the law you mentioned concerns. So the bill in question is the Commercial Rent Coronavirus Bill. It's currently going through the different stages of reading in the House of Commons. I believe it had its second reading just yesterday. The aim of the government is for this new bill to become law by the 25th of March 2022, so quite soon. Now, alongside it, we've got the updated Code of Practice for Commercial Property Relationships. So that's an update on the code that was previously in place. That provides quite a useful explanation of the proposed law and what we can expect to see from it. So that's well worth a read, very important document, but it also sets out the government's expectations of the behaviours which the parties to rent arrears disputes are expected to adopt to try to resolve their differences. The emphasis is really on people trying to resolve them rather than to have to resort to the arbitration process. Now, we're just in the early stages at the moment of this bill. Could well see some changes to it before it becomes law. We haven't got time, unfortunately, today to have a detailed discussion about it, but I can just take you through some of the key points. So the intention is for the new law to apply to ring-fenced arrears, and that will concern a period from the 21st of March 2020 in respect of arrears accruing from that point onwards until the date that restrictions on the closure of businesses were lifted, with the latest date being the 18th of July 2021. If you managed to get hold of a copy of the code, which is quite easy to find online, have a look at Annex A, because that lists the types of businesses which the law will apply to. We're talking here of businesses which were mandated, required to close for business during this particular period, such as non-essential retail, cinemas, the hospitality sector, restaurants, etc. So that will give you some clarity as to which businesses will be able to take advantage of this law. In terms of the rent arrears, as it were, that will be affected, it's not just purely the annual rent, but it will also include service charge, insurance rent, VAT, and interest. Now, either the tenant or the landlord will be able to apply under the scheme, or the new law, as it were, for the arbitration process to be used for the resolution of their dispute. They'll have a 6-month period from the passing of the Act to make a reference to arbitration. That period may well be extended, but at the moment that is the period that the legislation is proposing to bring in. So quite a short period, perhaps there to focus parties' minds to get on with and try to resolve their disputes.
I mean, these arbitrators you mentioned, then, could they actually conclude that no rent arrears are payable? So really leaving a landlord without any redress?
That's the current proposal, yeah. The Act sets out the arbitrator's powers, pretty broad powers, to be honest. They have quite a wide discretion, and they can essentially write off all the arrears or some, if that's what they think is appropriate, or indeed give the tenant time to pay. But there are two key principles really the arbitrators are going to have to bear in mind when making their decision. The first one is that the aim is to try to preserve the viability of the tenant's business when deciding what relief should be granted to the tenant, but that is not to come at the expense of the landlord's own solvency. The second point is that the tenant who can pay will be required to pay and won't get relief. But there may be some relief granted in the form, as I say, of giving them some time to pay to make the arrears affordable. In terms of timings, there's to be no more than a period of 24 months for payment to be made in respect of perhaps an instalment plan, for example, and that period will begin on the day on which the award is made.
And if the new scheme applies, then will it stop a landlord from taking any other action against those commercial tenants for those the arrears that have been ring-fenced?
Yes, the legislation intends to bring in some restrictions in respect of the ring-fenced arrears, so that the landlord won't be able to go after the tenant using its usual remedies for a prescribed period set out in the Act. So, for example, forfeiture, court proceedings, commercial rent arrears recovery, use of the tenant's deposit, and certain insolvency proceedings. These are going to be restricted so as to give the tenant that protection and to enable the arbitration process to be used. So, in summary, this law may well come in very soon. Certainly, the government hopes by the end of the first quarter, the rent quarter date. And but what final form it will take, I suppose, remains to be seen, because it's still going through the stages of its reading.
And then, of course, there's all the other landlords where the arrears that are owed to them don't fall within these ring-fenced arrears. Are they going to be able to simply fall back next year on the remedies that they would otherwise have, such as forfeiting leases?
Yes, well, as we all know, the Coronavirus Act imposed this restriction on landlords being able to forfeit for unpaid rent of commercial leases. That restriction is due to be lifted on the 25th of March next year. It might be lifted before that if, in fact, the law comes in sooner, but that's the current date. But whether or not we'll see a rush for landlords to actually use the remedy and appoint bailiffs to go in and change the locks, etc., remains to be seen. I suppose the usual considerations that a landlord will need to take into account will apply. Will they be able to find another tenant? Will they want to be saddled with an empty property and potential business rates liability? So those are the sorts of things that need to be considered.
And of course, some of these arrears will be relatively old by March next year if they began to accrue at the beginning of the pandemic. Do you think tenants are going to be able to use the sort of arguments that the landlord has waived its right by then to forfeit these leases?
I think that's unlikely, because what the landlords, what the Coronavirus Act also did, was to ensure that the landlord's conduct, or indeed conduct on its behalf, could not amount to waiver during the restricted period, save where the landlord expressly waives it in writing. And so waiver is unlikely to be an argument the tenant can run, but I suspect we may well see some creative arguments coming through the courts where tenants are looking back on correspondence they perhaps had with their landlords and trying to argue that it amounts to an express waiver. So we'll have to wait and see. But I think for those listening today, landlords and agents in particular, there is a key point here about waiver just to be remember, which is that once the restriction on forfeiture lifts, so too will the protection against waiver. And so landlords and agents need to be on their guard and remember all the usual steps and procedures they had in place pre-pandemic for ensuring that they don't unintentionally waive the remedy of the right to forfeit.
And no doubt that will leave still lots of levels of debt owed by tenants to landlords. I mean, do you think we're going to see more insolvencies next year?
I think that's the general consensus. Yeah, unfortunately, I should say, we will see a sharp rise in insolvencies. That's probably inevitable given the restrictions that were in place that are being lifted to protect vulnerable businesses. But some restrictions still remain in place, and as mentioned above, new ones are going to be brought in respect of the legislation just mentioned, at least for the ring-fenced arrears. There is still the current restriction in place for landlords concerning presenting and winding up petitions. That's in place until the 31st of March, but that's due to be lifted then so as to coincide with this new legislation. Of course, we've had some interesting developments in the last year or so with CVAs involving a number of disgruntled landlords who've had to bear the brunt of certain decisions, such as the Debenhams case, New Look, and the Virgin Active case. And we may well see some more cases like that, I suppose, depending on whether or not tenants decide to use the arbitration process or go down the CVA route. We'll have to wait and see. That is, however, slightly outside of my area of expertise, and one more really for my colleague and partner, Oliver Jackson, who heads up the insolvency and business recovery team here at TMH Stallant.
Thanks, James. I suppose from my point of view, in terms of commercial occupiers, I do a lot of business rates work and appeals. And so where are we going in terms of any reliefs offered to our commercial occupiers in terms of business rates next year? Well, the retail, hospitality and leisure sectors who have previously had a business rates relief during the pandemic of 100%, that will be continued into next year. Not at 100%, so at 50% from April 2022 through to March 2023. So that's some relief from them. But there will be a cap on that, which has been a little controversial, and that's a cap of 110,000 in terms of relief per business rather than per property. So if you have a retailer that has a number of shops, then that will go across all of those shops rather than each one. And it still leaves a number of occupiers that don't fall within those sectors, such as office occupiers and many other business slightly out in the cold. Many of those types of businesses have to date applied to challenge their business rates through what's called a material change in circumstances appeal. And now this enables the levels of rates payable to be reduced, because it looks at the property value if that has changed for things like the physical state and enjoyment of the property has changed, the mode and category of its occupation, all things that might seem quite obvious in terms of the pandemic, where we've seen all these empty offices and shops. But the government has recently put a stop to those types of appeals. So these appeals based on material change in circumstances effectively won't be proceeding. They initially put a stop in March 2021 in terms of appeals going forward. But very recently, we've had the Rating Coronavirus Directors Disqualification Dissolved Companies Bill, rolls off the tongue, which has reached the committee stage now at the House of Lords, and expecting it to come into law relatively soon. And what that basically says, it's going to, in the making of relevant determinations in relation to business rates appeals, no account is to be taken of any matter, whether arising before or after the passing of the Act that is directly or even indirectly attributable to coronavirus. So it's really covering all bases. It'll apply to applications that have already been made and future applications, so it's going to catch all of them. In terms of why the government, how the government's justified this position, is that it's saying market-wide economic changes in property values, such as those that have come from COVID-19, can only be properly considered at the sort of the general rates revaluation stages, which as from 2023 will be 3 yearly, so more frequent, and not at independent appeals throughout those periods. But instead, the government is providing a £1.5 million pot that it will distribute across the country, according to which sectors have suffered most economically, rather than on the basis of a fall in property values. So this pot will be allocated to local authorities based on the stock of properties that they have in their areas and those sectors that have most been affected by COVID-19. And then local authorities, using their knowledge of local businesses in their area and the local economy, will make awards out of that pot.
Emily, that's interesting. Thanks for that. Just a quick question. Will those occupiers that could have succeeded in their MCC appeals then get a share of this pot?
Well, unlikely in that we've had a couple of illustrative case studies that the government has shown us as to how this pot will be awarded. And what it looks like is the outcome will be quite different to how an MCC application would have worked. In fact, it's opposite also to how the government is approaching rent arrears. So the pot will be awarded irrespective of whether you could use your property or not. But it's all about whether you could continue to operate as a business. It's not designed, therefore, to help, the office occupier whose business could continue to function even though they weren't using their office, but everyone was working from home. It's more about, for example, the warehouse tenant that could still occupy because they could cater for social distancing in their property, for example, but there simply wasn't the demand for its goods that had sort of fallen off a cliff during the pandemic. So it's going to be quite a different outcome, I think, to MCC applications. When will this pot be available? Well, the government has simply said we'll work with and support local government to enable ratepayers to apply as soon as possible this year, I think maybe more realistically next year, because what they're going to have to do is wait for the legislation relating to MCC provisions to be passed, and then for local authorities, I mean, many of whom are represented in our audience this morning, to have set up these local relief schemes. So it is a bit of watch this space, but I anticipate that it will be coming in relatively soon. So turning to another topic in relation to commercial occupiers, obviously we have the terms of our commercial leases themselves. And Jonathan, if I can turn to you, what do you think the future holds in relation to what we may see being negotiated into commercial leases of the future that might sort of avoid the devastating effect that we've seen, heaven forbid there's another pandemic at some point?
Yes, thank you, Emily. Good morning, everybody. There's one big change I've noticed in the commercial leases I've been looking after over the last 18 months since the pandemic started. And just by way of a reminder to our audience, the historical position in commercial leases is that there's no rent suspension unless you have damage to the property caused by an insured risk like flooding or terrorism, where let's say that makes the property unoccupiable. So in those circumstances, subject to exceptions, normally the tenant would expect to have the rent suspended. Now, before March 2020, it was extremely rare to have rent suspension for anything else. I don't think I'd ever seen a lease which had said you'd have rent suspension for, let's say, a pandemic as well, because we just never imagined that would happen. So generally, the position under most commercial leases was if the tenants couldn't use their properties, then they had to carry on paying their rent. There have been some cases where tenants have tried to argue against that, but generally been unsuccessful. So yes, in answer to your question, we are seeing new rent suspension clauses. They tend to be sort of variations on a theme. So the sort of clause we're getting is that if there's a lockdown, so if the tenant is prevented from using its property by government action, the sort of the lockdowns we had last year and this year, then the rent will be suspended. Now, it's not quite as simple as that, because the first question is, well, how much of the rent is suspended? I've seen a real mixture. I've seen 100%, probably more often than anything else. I've seen 50%. And it all depends on what the parties can negotiate. So it depends on the bargaining strength of the parties. Now, the agents among our audience can, I think, really help the tenants here. Because if they can raise that in heads of terms stage, and if we get pandemic clauses set out in heads of terms, that's so much better for us as the lawyers. It's set out in the heads of terms and we can put it in the lease, or the landlord does, without having an argument. If we try and put it in as lawyers later, it's much harder to do. So I think there's something definitely the surveyors can think about in heads of terms, putting in these pandemic clauses. They're not easy clauses, because you sometimes have to think, for example, well, what if the government just recommends you to work from home? Should that result in a suspension? There's not an easy answer to that. And landlords might say, well, should there be exemptions? One exemption I've come across is where, let's say, a tenant has actually really led to its own property being shut. So let's say a tenant had a nightclub, wasn't running, complying with COVID rules, and it was forced to shut because of that. Now, in those circumstances, I think most people would argue the tenant shouldn't get rent suspension. So that has to be built into the drafting. You also see arguments about whether other sums are suspended, for example, service charge, insurance premiums. That's less usual, but if tenants can get those suspended as well, so much the better.
And what types of leases are we going to see these clauses in, do you think?
Well, it's interesting. I thought probably you would see them mainly in brand new leases, because those are ones you're starting from scratch and tenants have you've got a blank canvas and tenants can try and get that agreed. But I'm seeing them crop up more and more now in renewal leases under the 54 Act. So my initial thought was they wouldn't, because generally a 54 Act renewal is on the same terms. But I am starting to find that, especially with retailers who have a lot of properties, they're getting used to the fact and they're putting forward pandemic clauses in all their renewals, and to a large extent, I think, getting them. So the answer to that question is, my experience is they're appearing in a lot of leases, and it really depends. The more the tenants are represented at the start, the more likely they are to get their rent suspension clauses in.
And I suppose follow-up question then, is it only where the actual property, the property that's subject to the lease shuts down? What if, for example, you've got a shop in a shopping centre, that shop can remain open, but all other shops around it in the centre close?
Yeah, it's an interesting point, and it was subject to a case. Most of the clauses I've seen say that the rent is suspended if your property is closed. But there was a case with WH Smith last year in a big shopping centre. And this was all about the fact that it's a big shopping centre. Most of the shops were closed. They were all non-essential retailers. WH Smith stayed open, I think mainly because they had a post office, but clearly their trade dropped dramatically because there were very few people coming to the shopping centre. So that case was all about whether the rent should be suspended, not just if WH Smith's shop was closed, which it was unlikely to be, but if the other non-essential retailers were closed. And in that case, in fact, the landlord had agreed there would be a rent suspension clause, but it was all about the terms of that clause. And in that case, the court held that the trigger should be the closure of non-essential retailers, even if WH Smith themselves stayed open. So that's something to watch out for, especially if you're acting as a surveyor or a lawyer for a tenant, especially in a shopping centre where you can be badly affected by all the other shops closing, even if you are lucky enough to stay open. So I think, just looking forward from my point of view in commercial leases, I think these clauses are here to stay. We all hope there won't be any more lockdowns, but there might be. But I think well-advised tenants are really going to be looking to protect themselves and include these clauses in leases going forward.
Thanks, Jonathan. That's really useful. moving then on to our second theme for this morning, what's ahead in the residential arena? Well, we had a whole raft of things we could have chosen here. There's going to be some changes in terms of residential. We've had so many consultations, reports, government recommendations in this arena. There's bound to be changes in the years ahead. There's thoughts of abolishing ASTs, changing how one terminates a tenancy, and even a suggestion that tenancies should have some kind of rent controls. But choosing something for this morning, we just wanted to remind you about the changes coming in the world of enfranchisement, because these will definitely be seen in the next few years. I mean, the idea of residential leasehold reform in this arena started in earnest probably in 2017. And then in July 2020, we had some hefty Law Commission reports, which really set out a whole raft of recommendations. The government's stated aim in terms of this arena is to make it easier and to make it cheaper for leaseholders of residential properties to buy the freehold from their landlords or to extend their leases. And the first detail of what's coming in came in at the beginning of this year. We had the first stage of reforms announced, and they included the abolition of marriage value, which will bring premiums down, and also an online calculator, so there's consistency with the premiums being paid and one can work it out. There's also a single right for leaseholders to extend their leases by 990 years rather than the previous or current 90 years. And that will be at zero ground rent. And there'll also be a right to buy out the ground rent without extending your lease. In terms of when this is all coming in, well, we're expecting the draft legislation on these reforms sometime next year, but no indication of exactly when. So talking to the colleagues in my team that deal in this area, what they're seeing is that tenants are still seeing these changes are very uncertain, particularly in terms, obviously, of when it's all coming in. So generally, tenants are going ahead anyway with enfranchisement claims at the moment and lease extensions. The certainty of having their extension, for example, in place is much more valuable. And it's often motivated by things outside their control, such as their ability to sell their flat, for instance, or their ability to get a mortgage against that interest. Looking in terms of the freeholders of these buildings, a slightly different story. They're actually very worried, we're seeing, about losing value of ground rents at some point when the new changes come in. And they're currently working hard to try and come up with ways of dealing with the problem by offering commercial deals to tenants now. My colleagues have been advising on quite a few of these schemes and expect to be continuing to do so for some time yet. So there'll be lots of debate over this draft legislation. It's about people's homes, and it's therefore an emotive subject. And many have been very unhappy how long these reforms have taken to come in, but the legislation's got to be right. And there's a lot riding on it. There's been a lot of press attention. So it's not going to be quick, but it's certainly going to be quite fundamental reforms when they do come in. So in terms of ground rent, that's also going to be abolished for other residential leases. In May 2021, the government announced what's called the Leasehold Reform Ground Rent Bill into the House of Lords, and we're expecting that to be passed sometime next year. This bill will restrict ground rents on newly established, not existing, long residential leases, and it will reduce ground rents to a peppercorn, effectively restricting ground rents to zero financial value. The bill will also prohibit charging administrative charges in relation to those peppercorn rents. So there's no way of sort of getting round charging a rent like that. And it will apply to leases of dwellings granted on or after the commencement of the new law. So it's forward-looking, not retrospective. Certain types of leases will be accepted from these restrictions, so they won't apply to business leases, it won't apply to statutory lease extensions that we've just been talking about, community-led housing, for instance. And there are some special rules about shared ownership leases that will apply. If a landlord charges a ground rent under these new leases, then that will be a civil offence. And there are some fairly hefty financial penalties for doing so. The bill will place a duty on trading standards authorities in England and Wales to enforce it. Another job for our local authorities. And it also makes provisions for leaseholders to recover any rents that they have paid that were unlawful. In terms of the prediction for these measures coming in, well, I think it's going to certainly impact the structure of ongoing management of new residential developments. Developers currently receive obviously a ground rent income at the moment, which they're not going to get, and so there may be less incentive, say, for them to retain any management functions under this new regime. Talking of residential developments, slight leap to another subject, but when acting for them, certainly we often get faced with potential adverse possession claims. So you have a development site that has laid undeveloped for a while. You've got neighbouring homeowners that have sort of extended their gardens into this site, and you are faced with claims for adverse possession. James, I understand you've looked at this, and I'm hoping you're going to be able to tell us that the law around adverse possession is going to get a bit clearer.
Yeah. Thanks, Emily. Well, the government has just approved a number of recommendations which the Law Commission's been working on in respect of amendments to the Land Registration Act 2002. And one of the areas they've looked at is adverse possession. They've looked at a number of points. The one I'm just going to mention today concerns an amendment to the most popular condition that's relied upon by applicants when making a claim for adverse possession of registered land pursuant to the 10-year rule regime. Now, this is the condition which requires applicants to show that for a period of at least 10 years, they reasonably but mistakenly believe the land to be their own. Now, what's not clear at the moment, pursuant to the legislation, is whether that reasonable belief has to continue up to the date that the applicant makes the application to Land Registry. And the confusion has really been brought about by some commentary made in a Court of Appeal decision back in 2012. This commentary is not binding, but it's certainly persuasive. And the suggestion there was that the applicant needs to act promptly once their reasonable belief as to the position of the land is challenged. But what the Law Commission has proposed is that once a person's reasonable belief about who owns the land is challenged, they'll have a period of 12 months within which to make their application to the Land Registry if they wish to rely upon that condition. If they don't make their application in time, then they'll lose the right to be able to fall back on that particular condition if the landowner serves what's called a counter notice. And they'll then be left with just the other two conditions, which may or may not be applicable. So this amendment will, is much needed and will provide some clarity to the law, this particular part of the law of adverse possession. We don't yet know when it's going to become law, but hopefully, not too long now, hopefully next year. The Law Commission's been waiting on the government to look at these recommendations for quite some time. It's now done so and approved lots of them. So, all things are now looking to be moving in the right direction.
That's certainly good. It's certainly an area of law that needs some clarification. So skipping then on to our third topic or theme for this morning, real estate and the green agenda. I'm hoping, as I'm sure most of you are, that the pandemic will be a hot topic of the past soon. But then we will be faced certainly with the green agenda being, particularly following obviously COP26, being a critical hot topic of the near future. Chloe, I'm guessing, knowing a bit about the world of planning, that it's getting all set to embrace the importance of sustainability, of green developments, etc. Is that right?
Yes, that's right. Morning, everyone. Yes, only 2 weeks ago, the Environment Act was passed into law, and that's effectively the UK government's post-Brexit environmental law. So it contains legislation on a whole host of environmental issues. But one particular topic that I'd like to talk about is biodiversity net gain. So this legislation is intended to bring in a requirement for all new developments to provide or demonstrate a net gain in biodiversity of at least 10%, so quite a significant number. In addition to that, a requirement to manage and maintain that gain for a period of, at the moment it's proposed to be 30 years, but that can go up and down in the future as the legislation changes. And this is proposed to be secured through the planning process, through planning application and deemed planning condition at the moment. The intention is to try to seek these net gain measures either on site as a preference, if not on a local site, and if not that, then on a list of UK approved sites. And the type of measures that one may be looking at would be creating a new habitat, improving an existing habitat, more green roofs, green walkways, street trees, hedgehog highways, wildlife bats and bat boxes and that kind of thing. So this is unlikely to become law until 2023, but what we are expecting to see is secondary legislation, regulations and the like coming forward in draft. I think they're expected this autumn, but we haven't seen them yet. So we expect to see them in the near future, and the consultation on that and the government's response to the consultation next year. And I think this will be of interest to all parties, developers and local planning authorities, because they both have to deal with it when it comes into law. It will be, something to deal with in the planning process, maybe more cost involved and more time involved in getting these specialist reports undertaken and trying to identify these sites, and a cost, of course, for a developer in providing such gain in biodiversity. And of course, managing and maintaining it for 30 years, which is not a short period of time by any means. I think there may be sort of specialist management companies that may need to take this on, and, looking at maybe the service charge being passed on to purchasers as well. And another thing that in the sort of planning sphere that has just been announced by the government this week is the intention for all new developments to have electric vehicle charging points. That was only sort of recently announced in the news as an intention from the government this week. We haven't heard yet any detail of how that will be secured. It will presumably be through either the planning process or building regulations. So we wait to hear more on that. I expect we'll hear more about that next year. And predictions on this, will we see more planning conditions and restrictions on securing only electric vehicles to be parked in a particular area where there's parking stress, and the use of these electric vehicle charging points. So there's a few things going on in the world of planning and the environment.
And can you also just update us closer to home, in a sense, on the issue of water neutrality in Sussex?
Yes, so this is an issue which I'm sure our Sussex listeners will be aware of. Effectively, it affects a lot of the Southdown National Park, Chichester, Crawley, and also Horsham. It relates to the North Sussex Water Resource Zone, and Natural England in recent months issued a position statement setting out their concern that the supply of water from this zone cannot with certainty be said to not be having an adverse effect on the Arun Valley, which is a sort of special area. So there's concern effectively that there's too much water being taken from this zone and is negatively affecting a particular species of snail in particular. It is actually quite a major issue. It's currently holding up the grant of planning permissions in those areas where it's affected for those developments that can't demonstrate that the development will be water neutral. So what will we see? I know that local authorities are working really hard to try to figure out a solution on this, and as are developers and applicants too. I think we'll be seeing maybe some work next year towards trying to unlock this issue and figure out, how to better demonstrate water neutrality, build that into applications, maybe put in place some sort of policy, that the authority is putting in place some sort of policy to allow maybe a financial contribution or off-site mitigation to be provided to ensure water neutrality. But it certainly is a hot topic and something that I expect we'll see a lot more of next year.
Okay, thanks, Chloe. Jonathan, can I turn to you then on this subject of real estate and the green agenda? In terms of existing buildings, what are we going to see landlords having to do to bring their buildings up into sort of a more efficient standard? Because I think we've got some changes coming in via MEES.
Yes, Emily, there's a big day coming soon, not next year, but the year after, but it's going to be here before we know it. 1st of April 2023, always looked a long way away, but it's nearly here. That is when the rules change about energy performance certificates on existing commercial leases. So on April Fool's Day 2023, the rating on EPCs for commercial leases have to be E or above, E for Edward or above. If they're not, the lease isn't invalid, but the landlord is in breach of the minimum energy performance legislation. The landlord will be subject to a fine. The properties will be what is called substandard. And so landlords really need to start thinking about their properties and considering whether they ought to be carrying out changes to their properties to try and put up the energy rating. And
will landlords always be able to sort of enter these properties to get these works carried out?
Well, I think there's two things to think of here. If they're vacant, clearly the landlords can do what they want, subject to obtaining all necessary consents. If they're let, then, as we often say, it depends on what the lease says. Most leases, commercial leases, will allow the landlord to enter the property to do all sorts of things. There will often be conditions as to when they do it, giving notice, not causing any damage, not causing inconvenience, that sort of thing. But the landlords will need to look at their leases to see if they are allowed to go in to carry out the works, liaise with the tenant to do so.
And bigger question, obviously, who's going to bear the cost of these works, landlord or tenant?
Well, tenants are starting to get a bit worried about this. And another big change I've found in the last 15, 18 months is tenants worried that in their leases that they might have to foot some of the bill for the landlord carrying out energy improvement works, and the tenants don't think it's their responsibility. They feel it's a landlord responsibility. As a technical point, there's a statutory compliance clause in most leases. I think the general view is this probably wouldn't catch the tenant because the law doesn't say the landlord has to carry out works. It says the landlord is in breach if it doesn't carry out works. So there's a subtle difference. But a lot of tenants, especially those, again, with lots of properties, are, in my experience, trying to put forward a clause that says they don't have to either carry out any energy improvement works themselves or pay the cost if the landlord does so. Now, that's, from a tenant's point of view, that's very useful. Landlords have to decide whether they're willing to accept that. One point that I've come across is you have to be a little bit careful. If you just say, if you accept as a landlord the tenant doesn't have to carry out any energy improvement works, you have to be a little bit careful because there might be some circumstances where works the tenant does have to do might increase the energy efficiency as a sort of side effect. To take maybe an extreme example, if there's a hole in the roof, that probably falls in the tenant's repairing obligation, and you would expect the tenant to put that right, even if that increases the efficiency. So the drafting isn't easy, but as a tenant, it is definitely worth thinking about putting in these clauses to try and protect you against the cost. It's also worth thinking about service charge, because service charge clauses are drafted very widely. Usually, the landlords try and cover as much as they possibly can. And so as a tenant, again, perhaps putting some sort of exclusion in the service charge that says the tenant doesn't have to pay for works the landlord carries out to improve the energy efficiency of the building. That's definitely worth thinking about. Always with service charge, it's always worth bearing in mind, especially maybe for those of our listeners who deal with residential and commercial properties, that although there is legislation protecting residential tenants from service charge that's too high, there isn't any service charge protecting commercial tenants, and commercial tenants are simply governed by what the lease says. So you've got to get your protection in the lease. There's one other technical point that the rent review surveyors among the listeners need to think about. If you have a rent review and the property is substandard, I think it's slightly unclear how you would deal with the rent review. You'd have a property that can't lawfully be let. So it's worth thinking about changing the rent review assumptions, possibly to say you assume the property can be lawfully let. I mean, that is not an easy clause to deal with, but it's worth thinking about. And I think that may give rise to some discussions in the future. So again, looking forward, my view on those is those clauses, again, are here to stay. We're going to see a lot more about them, and landlords and tenants are going to have to decide what they're going to agree about energy improvement works.
And just finally then on that topic, Jonathan, are you finding that leases are seeking to deal with any other environmental related issues other than MEES?
Yes, a little bit. It's mostly MEES. You sometimes find at the moment, let's say with some of the bigger landlords with large buildings, that they're starting to put in sort of environmental related clauses about the parties working together to ensure that they carry out works, repairs in an environmental way, sustainably. Sometimes these are compulsory, sometimes just the intent of the parties. And so I'm seeing a bit of that. I suspect that'll come in more. Again, the tenants need to think about service charge effects. And another thing I suppose we are going to see, I think, is Chloe mentioned how the law is going to change on electric charging points. I think we'll find that tenants may well start to say, when they're negotiating leases, that they want to have a certain number of electric charging points for their cars, and perhaps that'll end up in heads of terms as well. So it's all such an evolving field, but I suspect we're going to end up with those. And I'm turning back to you, Emily. Do you think the green agenda is going to have an effect in property disputes going forward?
Yes, I think is the simple answer to that. I mean, it will have a different effect in different areas, but I can certainly see that it's going to have a role to play in the settlement of some future dilapidations claims, for instance. Perhaps because of a change of attitudes to the sort of work that's needed at lease end. So you've got Chloe's planning provisions will affect buildings of the future. Your new lease terms, Jonathan, will be providing answers perhaps for some new properties that are brought onto the market under new leases. But we've got all these existing buildings out there that are already let under current leases, and they've still got to hit their kind of net zero targets by 2050 as well. And as each of these leases fall in, that may well be the point, and maybe the only opportunity for landlords to then improve the green credentials of those buildings before then reletting them under these green leases that we're likely to see. And it may also become more difficult for sort of landlords to justify at that point ripping out and throwing away kit and fit out at these lease ends that in fact could be reused and has not actually reached the end of its economic life. And I think this will be more and more viewed as wasteful and as not keeping in with the green agenda. And perhaps even that term end of economic life will take on a new meaning, as we're encouraged, and indeed should be, looking at upcycling, recycling, reusing, etc., to reduce carbon emissions. So I think there's going to be pressure on the landlord to explore sort of more sustainable green approaches at lease end. And the often held assumption, I suppose you could call it, that landlords will insist on their tenants undertaking wholesale reinstatement as part of a dilapidations claim may need to be debunked. It might, such insistence might even become sort of a reputational issue for landlords. And then at the same time, as far as tenants are concerned, I mean, will incoming tenants want in future to be associated with brand newly fitted out buildings and all the carbon associated with that brand new kit, rather than looking at buildings that are reusing what's already there? I think it's therefore inevitable that we'll see some change in attitudes to works at lease end, and over the next few years, this will probably ultimately, lead to a change in the approach of dilapidations claims.
Emily, do you think these changing attitudes to reinstatement at lease end will provide tenants with a means of reducing landlords' dilapidations claims?
Again, yes, I think certainly when it comes to reinstatement. So the way that we look at reinstatement is it's damages that a landlord can recover to compensate that damages for loss it suffered. And the measure of that loss isn't about the individual landlord, it's about what are the reasonable costs that are for reasonable works that it's reasonable for the landlord to carry out. So it's this reasonable objective test that is imposed. And if you're judging that test against what's reasonable when you have in mind tenants and landlords with their carbon reduction targets and landlords and tenants embracing this kind of circular economy principle, then is it going to be reasonable for an objective landlord to require wholesale reinstatement? Probably not in all cases. So we can expect tenants to raise that as a defence, certainly to some dilapidations claims. Another defence that obviously we see, and the dilapidation surveyors in the audience will know well, is the use of supersession. So when we've got these MEES regulations coming in that will be requiring higher standards of buildings, landlords will themselves have their own published sustainability policies that tenants will be able to look at. And tenants will be looking at those together with lease cycles and voids when it's going to be possible for landlords to carry out necessary works to bring their buildings up to standard. And so they're going to be arguing that the works that the tenants would have carried out will be superseded by these necessary works in any event. So definitely opportunity, I think, for arguments to be made on tenants' behalves in relation to dilapidations claims. I mean, the optimist in me pictures that landlords and tenants are going to be like working seamlessly together to agree a sort of more green friendly dilapidation settlement on every claim, and that's not realistic. The reality is it's going to be a lot less smooth there. We've all got to get our heads, I think, round the new reasonableness standard that is going to be imposed, I suspect, in the future in light of the need to tackle climate change. So finally, I said we'd have a sort of sweep up session. I'm conscious of time on any other changes that we see on the horizon. James, if I can turn back to you, do you think there are any, say, legislative changes that are worth mentioning quickly on the agenda for 2022 and beyond?
Yeah, sure. Well, we've got the commercial rent prohibition of upward-only reviews bill. I don't think the draft's been published yet. The second reading, I believe, is the 18th of March of next year. So little details, but no doubt once that comes in, it will cause a stir amongst the valuers. We've also got the Landlord and Tenant Act 1954, which the government has said it wants to have a look at. I don't believe we know quite what they want to do with it yet, but that was last amended in 2004. So that's currently in the government sites. And I mentioned earlier, the Land Registration Act has been under the microscope. Just one point, I suppose, just to note from that, one of the recommendations of the Law Commission that's been accepted is for there to be a new statutory duty of care owed by conveyancers when it comes to identifying their clients. This is to try to protect against frauds arising where people pretend to be somebody they're not, pretend to be the owner of a property and then sell it, which unfortunately we saw in the press just recently. That poor person, I think, came home from holiday and found that their house had been sold to somebody else. They knocked on the door and they couldn't get in. So certainly that's a good step in the right direction. So yeah, that's just a quick short update on those points.
And Chloe, finally, in terms of planning, and no doubt there are more changes on the horizon. Any worthy of a quick mention now?
Yes, absolutely. Our listeners will no doubt remember that the government had released in August 2020 its Planning for the Future white paper, which the Prime Minister at the time said was a tear down and start again of the planning system, which suggested wide-ranging reforms, including zoning, admission in principle for particular zones, and huge changes to developer contributions, amongst other changes. Things have changed. I think that was very badly received within the Conservative Party itself. Its backbenchers didn't like it, and it's said to have been one of the contributing factors for their loss of the Chesham and Amersham by-election in June. So we haven't seen much progress with that. Ministers have changed now. The new minister with responsibility for planning is Michael Gove MP, and he sort of paused the progress on this, but he's been making noises recently about, you know, some changes that we may see in planning in the future, including things like the digitisation of planning, changing developer contributions and suggesting that maybe more can come from developer contributions from the increase in land value. So I think we will see that being slowly picked up. I don't think we'll see it as such a wide-ranging tear down and start again as had been billed, just because it was so poorly received. But I think that'll be something we'll see in the future, and I'm sure many of our listeners will be interested in that. I know that we've got a few new local authorities joining us listening today, who'll be interested in seeing what is proposed as well. So we'll be keeping everyone updated with our blog post bulletins and webinars on this point too.
Thanks, Chloe, for that summary at the end. Very conscious of time, trying to stick to my promise that we'll be done and dusted in an hour. I've got a few questions coming in. As I say, we will answer those directly to you by email. Just will pick up one point. Someone observant in the audience said, did I say the total pot for business rates relief was 1.5 billion? If I did, it was 1.5 billion, so apologies for that. A lot bigger indeed. So in closing, just want to thank you for joining us this morning. In terms of our next seminar stroke webinar, which is obviously a hot topic in itself, we are looking at the idea of returning to in-person events. We know there's quite a call for it amongst some of our audience, and we'll be sending out a survey with our next property and planning bulletin, asking you what you prefer, webinars, seminars, or some kind of hybrid that we haven't yet come up with, but sure we can. And the format will return to normal, so that's sort of 3 to 4 of topics with full slides. But do look out for our article that we'll be following this morning on the matters that we've discussed today, and some other ideas from some of our other colleagues in terms of what's on the horizon. And that just leaves me to say thank you very much for joining us. Enjoy the rest of your day, and we'll see you soon. Thanks. Bye-bye.